Welcome to our news updates. The crux of the federal case against the president's son that he lied on a federal form about drug use when he bought a gun is not typically the basis for a separate prosecution. At first glance, Hunter Biden appears to be at risk of up to 25 years in prison and a $750,000 fine if he is convicted on the 3 weapons charges brought against him by federal prosecutors on Thursday. In reality, few people fit Mr. Biden's profile. A non-violent first-time offender accused of lying on a federal firearms application who never used the weapon, in his case, a .38 Colt Cobra, which he for less money, more than 2 weeks and 5 years ago, commit a crime, receives severe prison sentences for the crimes charged in the indictment. Before we continue, please support us by clicking on the subscription button and turn on the notification bell for more updates. The mere act of impeachment is somewhat unusual, say former law enforcement officials, and the legal basis for the indictment is constitutionally questionable. Here is a summary of the allegations against President Biden's son and what makes the case unusual. How much are the fees? In the indictment written by a federal grand jury in Wilmington, Delaware, Mr. Biden on 3 felony counts, lying to a licensed firearms dealer, which carries a maximum penalty of 10 years in prison, making false statements on the federal firearms application used to select applicants, subject to up to 5 years in prison, and possession of an illegally obtained weapon from October 12 to 23, 2018, with a maximum sentence of 10 years. The charges stem from Mr. Biden's purchase of a gun at one of the lowest points in his turbulent life. He had been addicted to crack, had been in and out of rehab, was divorced, used prostitutes, and had money problems. The New York Times reported this year that Biden later told friends that he went to the gun store on a whim and bought the .38 because he thought spending time at a shooting range would help him avoid drug use. When purchasing the weapon, Biden had to fill out a federal background check form. When asked on the form whether he used drugs, Biden answered no, a claim prosecutors said was false. The first 2 allegations against Mr. Biden are essentially the same: that he lied about his drug use to illegally obtain the gun, and that he falsely claimed that he was not addicted to stimulants, narcotics, or other controlled medications. Substance, on the federal form known as 4473. The third charge, illegal possession of a weapon under the influence of drugs, dates back to the time when he owned the weapon. Holly Biden, his brother Beau's widow and his romantic partner at the time, eventually discovered the gun and threw it in a dumpster. The section of federal law cited in the indictment, 18 U.S. Code D 922, is the primary law used to define who can and cannot own a firearm. It bans drug users, people convicted of serious crimes with prison sentences exceeding 1 year, people escaping justice, people deemed mentally disabled, and people receiving dishonorable discharges from the Army. How common is this type of processing? A significant percentage of those charged with lying on a federal firearms application, as Mr. Biden has done, will not be charged with that charge unless they are also accused of an underlying, more serious crime. Current and former law enforcement officers. Most negotiate agreements that include probation and acceptance into programs that include counseling, supervision, and regular drug testing. It's rare for him to be independent, said John P. Fishwick Jr., who served as U.S. Attorney for the Western District of Virginia from 2015 to 2017. These charges are typically brought against convicted felons who illegally possess a weapon or commit a violent or drug-related crime. Prosecutions for lying to a dealer are relatively rare, averaging fewer than 300 per year. According to Washington Post statistics, between 25 and 30 million background checks were being conducted annually at the time of Biden's gun purchase. Charges of illegal gun possession are far more common, but they are also most often used as a supplement to take advantage of plea agreements or to ensure that a defendant is convicted of at least 1 charge when there is doubt that he will be convicted of an underlying charge, Mr. Fishwick and other former prosecutors said. For example, when more than 20 people in Savannah in May were sentenced to prison terms ranging from 10 months to 12 years after pleading guilty to illegal gun possession, all had a criminal record or were caught in the act of committing another crime. When officials at the Federal Bureau of Alcohol, Tobacco, Firearms and Explosives reviewed Hunter Biden's gun application a few years ago, they were convinced that if the target had been one less well-known person, the case would most likely have been dismissed because of the gun, according to a former police officer familiar with the situation. Biden has taken steps to get sober and stay sober. What happens now? No date has been set for Biden's arraignment in federal court in Wilmington. It is possible that the case will go to court. It's also possible that a federal judge could order the two sides to reach a similar agreement to Mr. Biden's lawyers had discussed an agreement known as a pretrial diversion agreement with David C. Weiss, Delaware's top federal prosecutor. As part of that doomed deal, the Justice Department agreed not to prosecute Biden for firearm purchases as long as Biden remained drug-free for 24 months and never owned a firearm again. The deal, negotiated by Weiss, who was appointed special counsel after the deal collapsed in a disastrous court hearing in late July, was more favorable to Biden than any deal he would get at that point. According to Biden's lawyer at the time, the agreement included a broad guarantee of immunity from prosecution in the firearms case and any possible charges arising from Mr. Biden's decision. Biden's work for foreign companies. Abe Lowell, Biden's lawyer, is urging the court to uphold the previous agreement, arguing that prosecution is precluded by the old agreement, the terms of which he says remain in effect. The judge in this case has not yet ruled on his request. Republicans called the original agreement a cheap deal and evidence that the Justice Department wanted to protect the president's son, even though Mr. Weiss was appointed by former President Donald J. Trump to investigate the case. Speaker Kevin McCarthy cited the case as one of the reasons House Republicans are launching an impeachment inquiry into President Biden. What is the constitutional question? Gun rights activists argue that prosecuting drug addicts for buying or possessing guns, especially those like Mr. Biden claims being sober for long periods of time, violates the right to bear arms. In recent years, there have been calls to change or remove the drug problem from the federal firearms application, particularly when it comes to marijuana use, but Congress has not changed federal firearms or drug laws, and federal officials have their regulations not weakened. In May, the ATF maintained that position, warning cannabis users in Minnesota that they would be prohibited from purchasing guns or ammunition despite the state's loosening of marijuana restrictions. But a 2022 Supreme Court ruling sparked a sweeping effort by gun rights advocates to roll back federal gun laws. The case New York State Rifle and Pistol Association v. Brune significantly expanded people's right to arm themselves in public. One case cited by Hunter Biden's team is a challenge to the criteria of the federal firearms background check system pending before the U.S. Congress' Court of Appeals for the 3rd District, which includes Delaware. If this lawsuit is successful, it could undermine the legal basis for his prosecution. If the court finds that it is unconstitutional to base a charge of illegal firearm possession on a violation of the law prohibiting sales to drug addicts, the other two charges brought against Biden, making false claims about drug use to get the gun, to get there, would probably collapse too, said Andrew Weissman, a former federal prosecutor and former FBI prosecutor. Officially, it is noteworthy that Special Counsel Weiss is bringing these charges not only because they are extremely rare, but because he is bringing them now, when the question of whether the law is constitutional is a lively issue. Said Weissman, who led Robert Mueller's investigation into the Trump campaign's ties to Russia. Thanks for watching. Let us know your thoughts in the comments section.